Hello, dear audiences, dear students. I am Ömer Ali Girgin. I am a research assistant in Anadolu Üniversitesi, Faculty of Law. My department is Civil Law, and I am here to introduce you the book Introduction to Law and Chapter 1. Okay, we will begin with the introduction part of our chapter. In this unit, we are going to have a general knowledge about law. In accordance with this purpose, first of all, we will define the law, try to understand how law existed, sources of law, and the relationship between law and morality. So, this is our first heading. What is law? Law is a set of rules which a particular country or community recognizes as regulating the actions of its members and which it may enforce by the courts. So, law is a set of rules. In other words, we can say body of rules. Legal definitions in laws may not mean the same thing these words mean in ordinary life. If we give an example, in Turkish Civil Code, the word child means person who is under 18. However, in ordinary life, you may not mention a 17-year-old teenager as a child. As you see, legal definitions are not interested in daily meanings of words. What are the functions of law? There are many of them. There are many functions of law, of course, but here we only mention the most important ones, such as rule of law, order, justice, rights, security, duties, freedoms, and framing conducts. If we emphasize, these are not the only functions of law, but these are the most important ones. Okay, there are two historical main ideas about law. First of them is positivist law idea, and second one is natural law idea. Let's see what are these ideas. In simple terms, for natural law thinkers, law is something beyond what is enacted, i.e., the rules of society or positive law. Positive law, on the other hand, is regarded as a compilation of rules which is established or recognized by the governmental authority. In easy or routine cases, a natural lawyer and a positivist lawyer may converge in their solutions, yet, in hard cases, it's quite likely that they will differ. Now, let's see what are legal traditions in the world. Mankind has seen a lot of codifications. The oldest one is Code of Hammurabi. Major legal traditions in the world are civil law and common law. Civil law is also known Continental Europe law, and common law is also known Anglo-Saxon and it was born in Britain. So civil law has some specialities, like civil law is codified, influenced by the reception of Roman law, and made by Parliament. But common law is uncodified, case law, not made by Parliament, based on precedent. These are not the only legal traditions in the world. Let's see different legal traditions in the world, except these most important ones we just said. So, for example, Islamic law, also known Sharia law, canon law, Jewish law, and Hindu law, we can say. The sources of law. Where does law come from? Sources of law is related to problem on which basis a judge will deal with a legal problem. In short, sources of law means where does a judge find the solution. The answer depends on the classification we made before. Remember the categorization we just made. We said There are two most important legal traditions in the world. One of them was civil law legal tradition, and second them was common law tradition. In civil law legal tradition, primary source of law in a legal system is positive law. We mean positive law, we mean codes, legislations, or simply we can say written law. In common law system, primary source of law is former decisions of courts, or simply we can say unwritten law. In Turkish law, by order, the constitution, statutes, international treaties, decrees with the effect of law, regulations, bylaws, customary laws, and judicial decisions, lastly, are the sources of law in Turkish law. How about law and morality? The close relationship of law and morality has long been considered worthy of examination. The similarity of the two in terms of the fact that they are both body of rules reveals the necessity of separating the two. In this context, the main difference between these two body of rules is that the rules of law are tied to material sanctions, but that there is no visible material sanction of the rules of morality. The law determines the rules that individuals have to obey in their relations with each other and with the state, and it puts sanctions on them. These legal sanctions establish the order in society. On the other hand, it can be defended that these two concepts are also different in terms of their aims. Law is aimed at realizing the justice, and morality is aimed at realizing the good with a plain expression. Finally, while the rules of law are mostly written, it's not possible to say same thing for moral rules. Even so, there are some situations in which law and morality go hand in hand, that the rules of law are influenced by the rules of morality while being created. In short, the rules of morality are protected by law. So, we have come to the end of this chapter. Thank you for listening.